Can I follow up on the first question that Ms. Bowe asked, which is, if you recall, about whether people were looking away, choosing not to see, or looking away because they don't want to get into trouble, or it's simply a matter of incompetence. I don't subscribe to incompetence on these facts here, especially for an organization like IDEC. I think one would have to give up on IDEC if one thought you are that incompetent, your office. An issue, and my follow-up is on an issue that I was going to raise with you, and I raise it now because you're going to the conclusion, and I think it's an appropriate time now. And this relates, it's still a similar theme to the first question that Ms. Bowe asked, but this relates to the bail issue. Now, Ms. Johnson testified to what happened, what that was all about. And the question asked of her was, who makes the decisions about we are going to oppose bail or we are not opposing? Who makes a decision about we're going to oppose the appeal or we are not opposing? So we had that engagement with her. But of particular interest to me is your role. You were in court when the bail condition, the contentious bail condition was imposed, which is these accused, they must not go to a crime intelligence office anywhere in the country. You were in court. You know that condition was not asked for by the state. But we also know from the appeal record that there was an engagement between the magistrate and Ms. Tlhatjwayo about the need to protect witnesses. And Ms. Tlhatjwayo's position was, we are not concerned about that because we have not given out names, and so we are not concerned about them going to the office. And yet the magistrate issued that bail condition, that they must not go anywhere into their offices. And if they needed anything, they must speak to Mr. Parayachi, to Colonel Parayachi. Now, Ms. Johnson testified, and I paraphrase very much what she said, that had she was not aware, she was not made aware that bail condition was not requested by the state. Had she been made aware after the fact that the bail condition has been, this bail condition was given, and it wasn't at the request of the state, but also the parties were never given an opportunity to address it, she would have, as any prosecutor should, as a responsibility to the court, and your ethical responsibility is you go back to the magistrate and you say you have to undo this. I don't remember the exact terminology, but you go and seek for it to be set aside because you didn't ask for it. And had she been aware on appeal, when this matter went to appeal, of that fact, that it was never asked for, she would not have supported you opposing the appeal. She depended on briefings from her officials, and she never got a briefing that this bail condition was given in the circumstances in which it was given, and every prosecutor has an ethical duty when something like that has happened, to go back to court. In fairness to the accused, your responsibility to the court, you go back to the court and say, you have to undo this. Now, you were in court. You knew that this bail condition was not asked for. You did not do what she says, what Ms. Johnson says any prosecutor would do, because you have an ethical duty for that. But not only do you not go back to court or tell Ms. Tlhatjwayo to go back to court, you in fact prepare and argue the appeal. You actually oppose the appeal on this condition, and you prepare the papers. In court, you do end up conceding because the appeal court is looking at the record, right, and says, but this and that didn't happen. You end up having to concede that because that's only fair to do. And the question is, as Ms. Bowe says, but how do you reconcile your position as a prosecutor who must prosecute matters without fear or favor or prejudice, who must be fair to accused as well, and therefore, and as part of your obligations as a prosecutor, is, well, if there's material that's favorable to the accused, you have an ethical obligation. And I know your code of conduct says that because I've seen that there. You have an ethical obligation to disclose even matter that is favorable to the accused, even if it's going to help them. Your job as a prosecutor is not to get a conviction or to get an incarceration at all costs. That's not your job. Ms. Johnson, having described what would have happened had she known, that's what she says, had she been briefed about this is what she would have done. Assume, for purpose of my question, that she wasn't briefed, because she's not my focus now. My focus is your actions in this, that how do you reconcile your role as prosecutor who knows the truth about this bail matter? You don't go back to court, and on appeal, you actively oppose the appeal. And before you comment, let me add something else that she said, had she known. She didn't understand how you would have gotten a condition that they don't go to any office in the country when in fact they're only based in Pretoria. And she didn't understand, and that was wrong for it to be in the bail condition. So that's one of the things that she said. She would have said, go and fix this. Explain how we reconcile your role and your position with what you did with this bail matter.
Okay. Thanks, Commissioner Balo. Firstly, like I said in the beginning, I was not part of this case. My first involvement is going to court to try and help a junior. I did not know how they had planned. I did not know the facts of the case. I did not know whether they were opposing bail or not. But what I realized was they were not even ready for the bail application, because when I asked for the bail statement from the investigating officer, I realized they don't even have one. So they addressed the court from the bar. So, but what I'm picking up from the evidence of Mr. Parayashi is that the prosecutor had been instructed to ask for that condition. I think Parayashi said that he spoke to the prosecutor on the day to say, ask for the condition, and that the prosecutor did not ask for the condition. Therefore, going to court, their plan, which I think they would have discussed then with the ID head, was, we're not going to oppose bail, but these are going to be our conditions. Therefore, I find it difficult when Advocate Johnson says she did not know about the condition, because based on what I hear from Mr. Parayashi, they were supposed to ask for that condition, but it was not asked for. But then the second point is, and I indicated that earlier to the court, I said, when I was brought in, it's for two reasons: to oversee the two cases, but most importantly, to prepare for the bail amendment, which is coming on the 13th of August. So Advocate Johnson knows that there's going to be a bail amendment application. So I'm brought in to oppose that. It was not my choice to oppose it. I did not come in and say, give me the part of opposing this. I'm brought in to oppose that, because she says the defense has a lawyer who is senior in her own right, and therefore I need you at that level. Now, what happened after the bail application and the first appearance, whether the prosecutor did not brief her, that I wouldn't know.
Even allowing for that, sorry to interrupt you, yes. Even allowing for that Ms. Tlachoyo did not brief her, you are now in the matter. You know what happened in the lower court at the time of the appeal, as you prepare the appeal. Why do you not at that point say, by the way, ID, you're saying I must deal with the appeal. Yes. But in fact, we did not ask. I was in court. That condition was not asked for. I'm assuming that you don't see anything wrong, for purpose of my discussion with you, with this wide condition that applies across the country. Forget that. Don't deal with that. But you know it's a condition that was not sought by the state. She says to you, prepare for bail, right? For opposing the bail appeal. At that point, why do you not say, because now you're in charge, why do you not say to her, by the way, it's a condition that we did not ask for. The magistrate gave it of his own initiative. We didn't get to address him, the accused did not, and as an ethical prosecutor or prosecuting body that we are, IDEC, we cannot or we should not oppose this appeal. Why do you not do that?
Yeah. Commissioner Malloy, there was, and this is my personal view, and there was nothing wrong with what the magistrate did. And I said the Criminal Procedure Act allows him to do what he did. Section 60, subsection 12 says the magistrate can impose any conditions which in the interest of justice would make him to come to. So even though the state did not ask for that condition, even though we did not address him at the time, the prosecutor did not address him, he imposed the condition after listening to the exchanges. There's this thing that comes up about witnesses. We don't want to release them, but we don't want them to be interfered with. There's other investigations that are outstanding. That I remember the prosecutor put on record. And having listened to that, the magistrate then gave this condition. Only the magistrate can explain why he gave that, but the law allows him to do that. And when I get instruction, go and defend it, it is on the basis that I know that there's nothing wrong that the magistrate did. And it is on the understanding that the unit wants that condition to stay. And that is why I'm going to defend. I couldn't say, yeah, but why must we defend this condition because we did not ask for it? Yes, we did not ask for it, but we wanted it if one follows the evidence of Padayashe and what he says he told Advocate Tlhatshwayo. He said he told Tlhatshwayo, ask for this condition. He's amazed also that it was not asked for. So that means the briefing was asked for the condition. It was given without being asked for. There's nothing wrong, nothing on our side that we did wrong as the prosecution, and therefore to defend it was proper at the time because it is a condition that the team wanted all along. The only problem is that they did not ask for it. But on the side of the magistrate is entitled by law to issue those conditions. Even if we do not address him, the magistrate can even deny an accused bail where we say we don't oppose him bail. We don't view him as a flight risk. Our investigations are completed. The magistrate, listening and looking at everything that has been presented to him, can do that on reasons, good reasons, lawful reasons.
Yes, but in this case, there were no reasons. That's where I had a problem with what you're saying, that it's a point you had to concede in the appeal court, right, that in the absence of reasons. And the part of the judgment that we are looking at, of the appeal judgment that deals with that bail interaction, there are no reasons, even in the engagement. In fact, your prosecutor keeps saying, and I struggle to understand that you think that was okay, that the prosecutor says, these people don't know the names of witnesses. They don't know who we are going to call. So there's no problem with protecting, which seems reasonable to me in the circumstances that, of course, if I don't know witnesses, how could I ever interfere with them? So the prosecutor, Ms. Tlhatshwayo, takes that position. The magistrate, nonetheless, gives her the bail condition. You know, as you sit in court, that the accused have not had a chance to deal with this. That's why you conceded in the court, in the appeal court. And I do have a problem that you defend this on the basis that, well, the magistrate can impose any condition. I don't think that's a correct position of the law. That wide. The magistrate could have said to them, you can't visit your mother because it's a bail condition. You would not struggle if I said to you, but what condition is that? That's an unreasonable condition. You would say to me, yes, of course it is unreasonable. So it's not as wide as he can pick and choose what he wants to do. But we are not even debating that. I'm raising with you what your then boss said about this, which suggests she was misled by the people that went to court, because that's really the essence of her testimony, and that includes you. She was misled by people who went to court in that they did not tell her that the magistrate gave us this condition when we did not ask for it. And she says, and she says, they have an ethical, as prosecutors, we have an ethical duty when something like that happens, to go back to court and say the parties were not heard, we didn't ask for this, you have to undo it. And if we have to argue it again, we'll argue it again. I was misled. My people failed me who went to court. So colloquially, she's throwing you under the bus, saying, are you saying you disagree with her that which she said should have happened, that you should have gone back to the magistrate. On appeal, you should have been the one that volunteers to the court that this is what happened in the lower court. Are you saying she's wrong when she says all of that?
Commissioner, what I'm saying is, indeed, she's throwing me under the bus in that she got me into the case to oppose the 63 bail amendment. But when she comes before the commission, she says something else, that as if I was doing things on my own. If she didn't instruct me to be part of the case, I wouldn't be sitting here today. She involves me in the case. I don't know what the brief to her was by Hlatshwayo, but she says specifically, because there's a senior lawyer involved there, I want a senior person to oppose this. And if she was of the view that, no, you were not supposed to benefit from that, go back to the court, lodge an application in terms of Section 63. The state, be an applicant yourself, where you ask the court to amend the bail application. 63 allows either the accused or the state can bring that application. But she didn't say to me, or to us at least, go and amend the bail condition because we did not ask for it. She said, oppose the application. We do that. But in the back of my mind, I'm not following. I can't follow. I'm not going to follow a wrong or an irregular or an unlawful instruction. I've never done that or never do that. But in the back of my mind is the magistrate was not wrong. The magistrate has powers to do that, but we're going to oppose. That is why even when it went on appeal, again with a blessing, we went and opposed it still. I engaged. The High Court judge took me to pieces. I tried arguing for my case. I did not get the first thing conceded. I tried and I said, this is what the law says, this is what the magistrate said, and these are case laws where I even referred the High Court to a case in Bloemfontein where an official of the NPA committed fraud against the NPA at the DPP's office, and one of the conditions there by the magistrate court was that he's barred from entering the NPA offices in the Free State. I raised that in our heads of arguments in the High Court, and that was confirmed in the High Court, where the High Court said those conditions must remain, and the magistrate must just add other conditions. So it happens. The powers are with the magistrate. It appears the IDEC wanted that condition. The head says to me, go and defend this. I can't say to them, no, why? And so I did that, and the amendment was abandoned, the application was abandoned. The Section 55 is brought in. Again, I'm giving instructions to oppose the Section 55 bail appeal. So I'm very sorry for the head to come before this commission and say, portray me as having acted on my own without consulting. It's just not true, and I did not take kindly to that because she brought me into the case for a specific purpose, to oppose the application and to oppose the bail appeal. That is why when I wrote a memo to her to say I'm recusing myself from the case for the reason I gave, she said, yes, it's fine, but please proceed and finalize these bail amendment and bail appeal. Take this one through. Did she know what she was setting me up for? I don't know. I thought at the time I'm just doing my job. I cannot sit here and say I was acting unethically. I did not. I did my job to the best of my abilities.
Yeah. Can I just say lastly from me on this, and I've heard your answer. As my recollection of Colonel Parachi's evidence is that he says he doesn't know where this bail condition comes from. He left court while Ms. Hlatshwayo was still on her feet. And at that time he left, they said not to come up. So maybe it happened after he left. That's what he has told us. But you have said earlier that he stayed for the whole time and left only when judgment. He missed just the judgment. So I'm mindful of your answer. But I must say that at best, it's a coincidence at best that a condition, on your version, a condition that was not asked for by the state, in fact, gets, and is not raised in open court, gets given by a magistrate. And a condition of this type, which is these accused are prohibited going to any crime intelligence office across the country, but two, the consequence of that condition is effectively they get suspended from their offices, from employment. It's quite a coincidence.
It is a very strange coincidence. I agree.
You accept that?
And if one looks at the evidence that is now before court, really one cannot rule out anything. But unfortunately enough, the prosecutor on the day, or fortunately enough, I did not ask for the condition, but then it's given. But for me, who was an outsider, I'm thinking, well, the magistrate has powers too. That is why we innocent prosecutors were just doing their job. And if there was any thing sinister going behind the scenes, it's something that we didn't know.
Thank you. Thank you, Mr.
Is
President.
it possible that this condition could have been discussed with the magistrate before the hearing started? Is it possible that the prosecutors went to the magistrate's chambers and said, look, this is what we are going to ask for? The reason I'm asking you this is you have just confirmed that it is a condition that Mr. Padiaki and the prosecutor had discussed before. So on their way there, that's what they wanted. It was just not discussed in open court. And then it becomes a coincidence that the very condition that they wanted, but they did not ask for in open court, is a condition that is attached to the granting of bail. So where else could the magistrate have got it from? And a condition that is so specific, if they had not discussed it with the magistrate, either during the hearing or prior to.
Yeah. Yes, Commissioner Kumal, one thing for sure, it was not discussed, at least in court, no, not in my presence in court. If it happened in some passages, in some corners there in court, I wouldn't know, because, like I say, I was back at the office when they're rushing me and my two other colleagues to go and help. And yes, it's strange. It's strange. But again, like, because no reasons are given, and that is why I understand what Commissioner Baloyi is saying, and which is what ultimately said by the High Court. The two parties are not engaged. It's like already the magistrate has made his own decision that I'm going to grant this. But I didn't suspect anything. I'm sitting here even today. I don't know. If things happened in those offices in court, again, it speaks to what we're hearing now. These things that we didn't know of, and it will be a sad thing for justice in this country if cases were discussed in offices, especially conditions of this nature, which will have a very critical impact on people's livelihood and their freedom of movement and freedom to go to work and fend for their families. If that was discussed before coming to court, it would really be
And just to be clear, I'm not suggesting that that's how it happened, because it would be unfair to the magistrate. No witness has said there was a discussion with the magistrate before the hearing. I'm simply asking because, we are on a fact-finding mission. We are exploring all possibilities.
Yeah.
And if you know anything, we want you to get the opportunity to comment on it. Because it may be that when other witnesses come here, we will ask them the same thing. So it's only in that context that I'm raising it. I'm not suggesting that there was a discussion with the magistrate. I'm not even suspecting that there was one. I'm simply asking because it is possible.
Yes, I hear that, commissioners. In my presence in court, that condition was not discussed or asked for by the prosecutors or by anyone.